So, Milliken v. Bradley, this is again another decision involving Chief Justice Berger. This decision, however, just 3 years after the Charlotte decision, has gone from unanimous to a 5-4 decision, to as sharply divided as the court can be. This case centers around Detroit and the Detroit Schools District and outlying areas and the issue of busing. So the parents of the black students in Detroit made the claim that Detroit was not de facto segregated, that there were no laws that segregated the school systems, but it was de jure segregated um, because the actions themselves perpetuated the segregated school system. It's not at all clear that the actions of the local school board really did perpetuate the segregation, but there was a de facto segregation clearly in hand. So the district court agrees with the parents of the black students and orders Detroit to come up with an integration plan. Um, and the court ordered the state and also the surrounding 3 counties to be part of that integration plan. So not only was the Detroit School District to be involved in the plan, but 3 outlying counties were also to be involved in that plan. Um, so on appeal, the Federal Circuit Court agrees, but only holds that the only feasible solution is to integrating just Detroit, and that going outside of that area was too broad, too much power. But the Supreme Court in Miliken disagrees and basically says that you can't solve some things. For the court, they said the surrounding counties surrounding Detroit um, didn't weren't even charged to have violated desegregation efforts. Um, so they should not have to comply. Um, the court says very clearly that inter-district-based remedies are only appropriate where district lines were deliberately drawn because of race, and that is not apparent in this case. Um, Furthermore, it's been widely recognized that public education is a local concern, and so including 4 separate counties in one integration plan does not meet that local definition. In fact, it's fairly large. Um, the Supreme Court does find some de jure discrimination in Detroit. So a Detroit-only desegregation plan has to be fashioned. So the court says the plan is too broad as is, but there is some de jure desegregation going on in Detroit, but you must come up with a plan that solves for Detroit and can't include these outlying areas. Let me give you some context about what happened to Detroit in the 1940s, 1930s, 40s, and 50s, really. The Detroit of the 1920s and 30s and 40s was segregated, but it was segregated within the city. And so one could have seen if you were to desegregate the schools there, it would be very difficult to come up with an integrated solution. But what happened is individuals who were in the city, whom were white, who began making more money through, in essence, the number of factory jobs that existed in Detroit at the time, moved to the suburbs and commuted for their job, but lived in the suburbs. And what ultimately happened is these suburbs became predominantly white, leaving the core of Detroit strongly African-American in population. And so the school districts that were outlying in this area, while predominantly white, really didn't have any sort of impediments for African-American students to go to those schools. But the function was there weren't many African Americans in the area. And so there simply weren't many African Americans in the schools. By the same token, in Detroit, you saw very much the reverse, in which there weren't a lot of white students, and so these schools were predominantly African American. And so the solution that the district court judge and others came up with was to simply bus across those district lines. Now, the reason why possibly that was so unpopular is that's a trek. Um, to go from some of the outlying areas from Detroit and in Wayne County and surrounding areas, that can be upwards of an hour on a bus twice a day, um, which means that school, even if it starts at 7:10, in essence, you've got to start your day at 5 in the morning. And that means everyone has to start their day at 5 in the morning in the household. So it wasn't a predominantly popular plan. But the Supreme Court sort of weighs in and says, you can't do that much here. There's a prominent dissent on the court, and one that I want you to focus on, and that's Justice Marshall. Now, you should know of Marshall. Marshall was indeed one of the architects of the NAACP's plan to strike down separate but equal education across the United States. He was one of the architects of ending segregation in the school system. His dissent points at those in the majority and basically says that they're following public opinion and courts shouldn't do that. He says that today's holding, I fear, is more a reflection of perceived public mood that we have gone far enough in enforcing constitutional guarantees of equal justice than it is a product of neutral principles of the law. So he calls the majority to task for basically being politicians, which, as someone who studies judges, I have no problem with judges being considered politicians because they are. But there exists, at least among judges, a sort of, this was a very offensive comment by Justice Marshall to make to those who were in the majority. Judges don't like to think of themselves as politicians, and they largely like to think of themselves as immune from sways in sort of public discourse and public mood. So this was a very, very strong rebuke of the majority. And there's no question, by the way, that Justice Marshall was absolutely correct in this regard. He understood that in order to get the goal to where you wanted to be in terms of an integrated school population, you have to come up with some plans that aren't based solely based on local characteristics. So why do we see a change from Swan to Miliken? So what happens in these 3 intervening years? Or what happens that is different here? Well, first off, Charlotte School District included the outlying areas and they were all part of the suit. That's not true for the Detroit case. So the one thing about Charlotte is all of the outlying areas were under the same school district. They were under the same school board. So jurisdiction there wasn't so much of an issue. Also understand the Supreme Court has modified during this time. In these 3 intervening years, President Nixon had appointed all four of his justices to the Supreme Court. So Nixon appoints 4 justices. They're all on the court at this time. So while it was still a 5-4 liberal court, Nixon is sort of getting his way here, and the court is becoming more conservative. But we have to understand that Chief Justice Burger wrote the decision in Swan, and he also writes the decision in Miliken. So this is also a story about the change of Chief Justice Burger. Perhaps he felt Swan had gone too far. Perhaps he felt the pressures of public opinion. But something very clearly has changed from 1971 to 1974, at least in the jurisprudence of Chief Justice Burger, that affects this outcome. And this becomes a regular battle on the court, really for the next 20 years, about what the scope of desegregation and integration efforts look like, and what really the finish line is. And that's really what we're going to get to in the next case is a discussion of where's the finish line? What does it look like? And how do we know if we've actually met the dictates of Brown 1 and Brown 2?